My name is Jason Roth with the law firm of Roth Davies in Overland Park, Kansas. One of the questions I get is who are subject to the federal motor carrier safety regulations and how do those regulations define employers and employees? The federal regulations apply to all employers, employees, and commercial motor vehicles that transport property or passengers in interstate commerce. Interstate commerce refers to trade, traffic, or transportation that crosses state or national lines. This includes companies that operate vehicles for their own private use, as well as those transporting goods or passengers for compensation, also known as for hire. It makes no difference if the vehicle is leased, borrowed, rented, or owned, and whether the vehicle is empty or loaded. All of these scenarios are subject to the federal regulations. There are some exemptions for those who are subject to the federal regulations. Most often, these exemptions are based on the size of the vehicle, the type of operation, or the commodity being transported. The Federal Motor Carrier Safety Administration defines employers and employees to specify who would be subject to the federal regulations. An employer is defined as any person engaged in business affecting interstate commerce who owns or leases a commercial motor vehicle in connection with that business or assigns employees to operate it. An employee is an individual other than an employer who is employed by an employer and who in the course of employment directly affects commercial motor vehicle safety. This includes drivers, independent contractors, mechanics, and freight handlers. Accordingly, if an employer or employee falls within these definitions, they are subject to the Federal Motor Carrier Safety Regulations. If you have any questions regarding trucking, truck safety, or the application of the Federal Motor Carrier Safety Regulations, please feel free to call 913-451-9500. Thank you.